Started. Welcome to the INREM podcast, where we discuss the law for real estate investors. Andy and Sean are both attorneys. Nothing said in this discussion should be considered legal advice. We're simply providing information and education. You should consult with an attorney in your state regarding any specific legal issue that you may have. All right, everybody, happy Tuesday. I'm Andy Fowler, and I'm here with Sean St. Clair. If you're new to the show, give us a like. Subscribe to our channel, whether that's Facebook, whether that's a YouTube channel. That helps us provide more and better content to you, helpful content that you can use in your own investing. Also, leave us a comment below. We want to hear from you. We want to see what questions you might have. We've got two amazing guests on the show with us today. So if you have comments and you have questions, we're going to try to get to those and see if we can get your questions answered. With that, right now, we're going to go to Sean, who's going to give us a legal update.
Thank you, Andy. So my update today involves a recent decision by our Arizona Supreme Court dealing with homeowners associations. And one of the big issues that we see on a regular basis with homeowners associations is basically they do not like rentals. And more specifically, they don't like short-term rentals. And they're always trying to change the rules and regulations of the community to eliminate short-term rentals. And at times, they're able to obtain enough votes to amend the CC&Rs. To amend the CC&Rs is difficult generally because you don't need just a quorum at a meeting to amend or alter the CC&Rs. You actually have to have the requisite number of owners within the community to vote in favor of the amendment. So that generally requires anywhere from 50% or 51% of all of the owners within the community, or sometimes it could be 2/3 of the members or 70% or 75% of the members within the community who must agree to amend the CC&Rs. So more recently, we're seeing homeowners associations working to amend the CC&Rs instead of trying to pass rules and regulations. And the reason is because rules and regulations cannot be utilized to restrict rentals or restrict property rights within the community. The rules and regulations are going to be trumped by the declaration. So if the declaration is silent on rentals or short-term rentals within the community, you can't pass rules and regulations as a board, which are going to restrict the use of the property in that nature. Instead, you have to amend the CC&Rs. So these communities are going around and trying to amend the CC&Rs to restrict short-term rentals within their community. And some of them have actually been successful in doing it. And we've started to see litigation in our Superior Court here over the validity of those amendments. Well, Arizona, specifically our Supreme Court, came out with a recent decision called Callaway versus Calabria Ranch HOA, which doesn't specifically deal with short-term rentals or rental restrictions, but the nature of the case and the holding of our Supreme Court goes a long way to basically limiting the power of homeowners associations from amending the declarations to restrict the short-term rental of units within their community when the original declaration is silent as to the use of the property in that way. So in the Callaway case, the homeowners association there basically said, okay, we're going to impose certain subdivision requirements upon the owners. We're going to restrict and put onerous conditions upon the sale of properties within the community. And then they put in a number of other restrictions, some of which deals with livestock and things like that. And so the homeowners who were burdened by this amendment to the CC&Rs, they decided, okay, well, we're going to go and file a lawsuit, and we're going to challenge the validity of these CC&Rs. And it went all the way from the Superior Court to the Court of Appeals, and then all the way up to our Arizona Supreme Court. And our Arizona Supreme Court struck most of those amendments. And when I say struck, they didn't just keep them in place for future owners and say, but retroactively, we're not going to impose them on the current owners. They actually took, what we call blue line. They blue lined the amendments so that they're unenforceable and not even part of the CC&Rs or declaration going forward. Now, I'm using some legalese here, so I want to take a step back. When I say CC&Rs and declaration, I'm talking about the same thing. It's basically the restrictions that are imposed upon the community. Sometimes they're referred to as a declaration. Sometimes they're referred to as CC&Rs, but it's the same thing. It's basically that document that was created generally when the community was created, that basically says, here's how you can use your property within the community. So the Supreme Court strikes these amendments, and basically what the Supreme Court says is that amendments must be reasonable and foreseeable. And for an amendment to be reasonable and foreseeable, the original declaration or the original CC&Rs must provide notice to the owners that in the future, they may be subject to the new restrictions. The CC&Rs cannot be silent on the new restriction or the issue. For example, in this case, it would be, if we're talking about short-term rentals, the CC&Rs can't be silent on the rental of property, or be silent upon the time frame or time restrictions imposed on rentals of property. They have to actually give some sort of notice to the existing owners that, hey, there are rental restrictions within the community, and those rental restrictions may be subject to being, amended and changed. But if the CC&Rs or declaration don't have any of those restrictions, the HOA under this Callaway case would be prohibited from then going and all of a sudden imposing restrictions that otherwise didn't exist. While this is an Arizona specific case, I know there's cases similar to this in California and some other states. So it's something to keep in mind if you are owning property that you're using or intend to use as a short-term rental. Number one, check the CC&Rs, check the declaration, make sure that there's no prohibitions. But assuming there isn't, be aware that there is case authority here in Arizona and some other states that would prohibit the HOA from later coming in and restricting the use of the property in that way.
Now, Sean, have you seen investors that you've worked with start to use this as essentially a strategy to look for, hey, we see that there's some restrictions here that are not favorable to what we want to do with this property, but it looks like the declaration doesn't give fair notice on what they do. We think this might be ripe for our own challenge.
Yes. Owning short-term rentals, VRBOs, Airbnbs is very, popular. It's huge right now. And so I do see owners that are buying into these communities, reviewing the CC&Rs, and they should be before they purchase, to make sure that there aren't those restrictions. And then if the HOA does become aggressive, we've seen homeowners who are now pursuing litigation. Now this case is less than 60 days old.
Sure.
And so we've not seen this case be utilized, although it is on the radar of the litigation attorneys within our office who are dealing with these types of issues. And they're aware of this case, and they believe that it will be helpful in challenging any type of CC&Rs or declarations that restrict short-term rentals. But I think we're going to be seeing a lot more of this type of litigation because there's more and more people who are buying investment properties for purposes of, using them as short-term rentals. And we have a lot of established homeowners and board members on HOAs who don't like that. And so they're looking for ways to shut those down. And in Arizona, our legislature is very friendly to short-term rentals. In fact, there's a statute that prohibits municipalities from imposing restrictions on short-term rentals, and basically says, hey, statewide, this is something that can be done, and no, municipal government can restrict it. Now, that doesn't apply to CC&R. So if the declaration has those restrictions, then you can't use it. But if the declaration doesn't have those amendments or those restrictions, and then the HOA later goes and amends it, arguably under this Callaway case, those amendments wouldn't hold up and would be stricken by the court.
Sure. So know that if the declaration doesn't give notice, you still may have an investment opportunity here. Now, it's going to mean one of two things for sure. It's going to mean either lobbying the HOA board and community to change the rule, or it's going to mean litigation in order to strike an invalid rules, regulations, or amendments that don't comply with the declaration notice.
Absolutely.
To shut that down. All right. Let's get into today's topic. Today's topic we titled Weathering the Storm, Clearing Clouds on Real Estate Title. You've all been there, or a lot of people have been there. And if you're an investor in the space, you've seen it. You're moving fast on a deal. You're loving what you're finding. And then you get it into escrow, and there are the real estate term is clouds on title. That means there is a problem with the title that typically is going to have to be fixed prior to you closing on that title. So that's our topic today. We're going to talk about the strategies involved, strategies that we as attorneys or real estate investors are using to resolving those clouds on title. Today with us to discuss those topics and give us their background as well as their experience in the matter is Tyler Epstein. Tyler is a real estate attorney in Texas, and Logan Fullmer, a real estate investor also in Texas. Tyler and Logan, thanks for being on the show. We appreciate it. So happy to have you.
Absolutely. We appreciate the invite.
Yeah, for sure. So, Tyler, I want to start with you. Just give us, our listeners, kind of an idea how you got into this space in the unique real estate market of representing real estate investors and helping them solve title problems.
Well, I got into it because I don't like attorneys. I had several opportunities in dealing with properties and dealing with other attorneys, and realized that very few of them were paying attention to the rules and were really just generally dragging things out. And so I just looked at it and realized if they could get paid doing a bad job, I figured I could get paid doing a good job.
Awesome. And Logan, I know you're a real estate investor in Texas. What got you into this line of work?
I did several real estate deals that were pretty simple and clean and easy, and they were all right. And I did several of them that were messy, and I kind of got that don't give up attitude. And at the end of the road, I looked back and realized, boy, those messy ones were the ones that made the most sense to me in terms of, finance. So I just started kind of going towards those because they looked better at the end of the day to me.
Tyler, as we get into this, I want to ask you guys a couple general questions, but we're going to kind of get into this. Sean and I, as Arizona attorneys, we often see things through the Arizona lens, and we like to compare and contrast how folks in the same industry are doing what we're doing in other places, what they're seeing, how they're getting problems solved. What are some common title issues you're seeing right now, if you had to kind of identify the most common?
Right now, what I'm seeing is a lot of gaps in title. People are not transferring the asset from, nobody's probating the will of grandma and grandpa, and it just carries forward. And now it's 50 years later, and 18 to 40 heirs all in the mix that all own partial interest. That's the biggest thing. Or I'm starting to see some of these old lake developments that happened in Texas back in the 60s and 70s, realizing that those guys that were the real estate players back then, they were just running everything out of their shop, right? Like, I mean, they just had a form deed, and it's all messed up. And who knows, they may have been living on lot 14, but they bought lot 8 because nobody was doing any double checking of the paperwork. So that's also part of it.
It's interesting is we're in Texas, and when folks started coming to the United States and putting roots down, Texas is one of the early places they came when folks started heading west. So we've got a lot of really old land titles, and some of our big cities, for example, San Antonio, the southern cities, have super old land records. So when you give humans a chance to screw something up, they're going to usually do it. And when you got a lot older land titles in volume, specifically in South Texas, you got a lot more probability for mistakes. So that's why we have a pretty big volume of problem title transactions here.
Yeah, I feel like some of this could harken back to the creation of the quitclaim deed. For some reason, when the quitclaim deed came about, everybody and their brother and their mother decided, well, I guess it's just super easy to convey title to real estate, and we'll just do it via quitclaim deed, and then you get problems.
Well, in Texas, until about the 70s, a lot of transfers didn't have title insurance. So you had a lot of people in Texas that just pulled the form and they just did the deal, right? And just took it to the courthouse together, and the clerk just filed it. And everybody was happy until the next door property now has highway frontage and Walmart's going in or development's going in, and they're like, well, that's my property. And it's not, because they didn't, they just said, well, we're going to do about, I've actually got a deed that I'm working on right now that is about 350 feet west, about 800 foot north, and then it cuts back east to the road frontage. Well, that road isn't there anymore. And so, like the surveyor's like, we don't know what this means. Nobody knows what it means. We're just going to try to figure it out.
So given those are the most common, some of the most common issues you're seeing, what kind of issues in terms of rating on the scale of complexity for you? What kind of issues are you seeing that are taking the most time or have the most complexity to solve, whether it's because the procedural road that the Texas courts require, or just what's involved to get it cured?
Access is the most difficult to fix, is access. If you have a landlocked parcel or a parcel that doesn't have deeded access, because there is no quick and easy route to get there. It requires blunt research in abstracting all the title around it to look for potential access, all the way back to creation, all the way back to patent for each one of them. And then you have to have a survey. I've got Logan likes to brag about spending $20,000 and $30,000 a month on attorneys. I spend $20,000 and $30,000 a month on surveyors. Surveying property in 1910. And so they're having to recreate layers of surveys. So we'll have a survey from 1910, one who owned the properties in 1950, and then again in 1990, just so I can lay it over the top of each other and paint a picture in time.
So does Texas have easement by necessity, where if you don't have anything out there, you can force it over a neighbor's property? And explain what easement by necessity is. We're using some legalese here.
So an easement by necessity, your immediate thought in Texas is that means that if you have landlocked property, you have an easement by necessity.
It's like the catch-all here. If none of the other 3 common law remedies work, that's your last hope.
Yeah, and it's not a sure shot. It does not mean that you win, because the Supreme Court has decided that at the time of the partition, the easement by necessity that you are seeking had to give you access to a public road that existed then. So if it was partitioned in 1910, you better hope you knew where the county road or a public road was in 1910, and that easement by necessity had to get you there. And where it gets very interesting is there are landlocked properties in Texas that forever landlocked unless you buy an easement, because there wasn't a road there, or there was a road, but it was owned by two different property owners because it was two different abstracts, and you're like, oof. And you would think that it can't happen, but it does.
So the part where, a lot of folks go down this road is there statutory law that's going to help us out? Is there a common law remedy? What kind of options do we have? And sometimes you wind yourself up in a corner that way, and the lawyers will say, you ain't got nothing, it's over with. And then sometimes this gunslinger, maybe like me, or Tyler's more like this than he is a normal lawyer, but a lot of lawyers don't think this way. You say, okay, well, let's pick one of these causes and let's file the thing anyway. And as long as they can't get us wiped out on a summary judgment, we'll fight these knuckleheads for 6 months and make them spend a bunch of money. And then all of a sudden they decide to settle and we actually mediate an easement, whereas we may not have actually been able to get one if we went all the way through to a jury or bench trial.
So what you're describing is a situation where you may or may not be able to establish your easement by necessity, but
Right.
hey, let's, create an inventive negotiation, right? Let's create some event that causes them to want to come to the negotiation table so you can essentially buy an easement from them, right? Or somehow work out an arrangement where you can then, obtain an easement. Is that?
Yeah, I mean, sometimes you'll find judgments and liens. I mean, this is pretty rough stuff here, but when you're in a spot where you have hundreds of acres that are locked, you're in trouble. You got to do something, and sometimes drastic measures are important. So you might find judgments or liens indexed against these folks, or maybe the incomplete estate that their parents left, and there are judgments and liens out there that are 6 years old. You can buy them for pennies on the dollar, and you may all of a sudden now have leverage against that real estate because that could be a creditor claim. So you got to sometimes really dig deep.
Yeah,
you got to dig deep, and as Logan, you look for the leverage, and sometimes it's there and sometimes it's not. If you can find leverage, then you can go, you approach everything first as a helping hand. Like, this is going to happen. Let's make it work for both of us. And when that fails, then you've got to be on your game for litigation strategy and at the same time making sure that you can, run faster than they can in some instances.
To step further back, sometimes you say, dang, this is real aggressive, and oh my gosh, that doesn't sound very nice. But what you got to remember is you're trying to get access to a piece of property that needs it anyway. There's a piece of land that somebody's going to get to use or should have access to, and a mistake was made. So you're trying to cure that mistake that was happened at one point and make this usable. So we're not looking to aggressively take over somebody's business that they started or whatever. We're trying to solve this, and sometimes the methods to get there have to be pretty tough, but at the end of the day, you are trying to do something good, and you're not really going to damage another person's 400 acres by giving you that 20-foot path. So it really is for the greater good almost.
Well, yeah, I mean, our country was founded on the idea of private property rights and, being able to utilize property to its, fullest potential. And when you have a landlocked property, you're not doing that. It's useless, right? So interesting.
Right.
So that's the fun. I mean, the research that goes into this, and this is where some people don't understand. Well, the property's worth $1 million. Right. It's worth $1 million with access. It's going to cost me $300,000 to $400,000 potentially. It may only cost me $50,000. But if I have to go do all the research and go to the archives and go to the GLO, the General Land Office in Austin, and pull the survey from patent from whether it came from Spain, Mexico, or Texas, and then translate it, get it all squared away, and then move forward with it, then you're looking at, $50,000 in surveying fees, right? Just to make sure that that's done.
So you mentioned Texas. Are you guys doing any of this outside of Texas?
Not yet.
Not yet. Okay. But thinking about it, maybe.
I'm aggressively, like I said, I'm aggressively seeking a few other states.
Okay.
One is California for sure.
Yeah.
And then Arkansas, Mississippi, Alabama, Georgia, even Tennessee, a lot. Well, and it just comes from a legal background. Texas didn't have law when it became a state, right? So it just adapted statutes out of Tennessee or Alabama, and so the laws track very similarly. Now they've diverged since then, but your foundation principles are the same. So then you just have to read, right? and a lot of this stuff in real estate law, honestly, I like to call it the Betty Crocker of law, because you just have to read the statutes and follow the instructions, right? Like most of this stuff is statutory outlined over the years of case law, and the legislature and so you just read the rules and you follow them strictly. And, and then real estate generally has a lot of money behind it. So you have a lot of case law to then support yourself, because somebody has found it, and especially in Texas with the oil and gas, there's a whole lot of fighting going on. And so you get some very good layers of case law.
Interesting. Tyler and Logan, I want to go through a couple specific areas that we run into, kind of get your guys' take on it, what you're doing to fix and cure these type of issues. What are you doing with unreleased deeds of trust mortgages? The title company pulls the history, and we've got a deed of trust that hasn't been released, but it was paid off.
Well,
the first thing that, if we can prove that it was paid off, and you have a good escrow officer that can communicate with your underwriter, you can sometimes just get it kicked over. It depends on how long ago it was. The other time is prove if they went out of business. And then the last one that you have is what I find is just sue them. Everybody's like, well, send a demand letter. I've never seen anybody answer a demand letter that's in a big business. So just file the suit, and it speeds things up because they got 20 days to respond.
Yeah, the very first thing I tell folks is usually I'm dealing with a property that I want to buy, and we have this problem. So I'm not offering it, and Tyler's most times not offering it as a service provider, but as a principal in the deal. First thing I do is find out, did you pay the thing off? They say yes. I say, can you prove it? If they tell me yes, I say, all right, let's go to your house and look through your file cabinet, because I bet you with that payoff statement or within the month or two after that, you probably got this release in your file cabinet. So we get lucky and find them at home sometimes with the sellers. And where Tyler mentioned, find out if that entity is still any good or not. So the FDIC's got a website, and you can go and put in that bank name, and you'd be surprised how many banks have been forfeited, and there's no other record of where their assets went. And if on that website it says assets forfeited, it doesn't list the destination for those bank assets. I've provided a PDF of that to title many times, and they'll completely wipe that requirement from the Schedule C and move on.
Well, your underwriters are a lot more lenient than ours.
Well, so let's talk about that. That's a really important part. So, I look at this and say, what happens if a title company has to pay out a claim? What are they going to do? They're going to go sue the last guy, even if they got a title policy, and that's the deal. Mm-hmm. They're going to send demand letters. They're going to run you up the flagpole and try to weasel some money out of you, whether they lose a lawsuit or win one against you. They're going to do it. So I look at this stuff myself and say, what are the odds of this coming back on the title company or me? And if I satisfy myself to feel like, man, there's about a 2 chance in 100 that it's going to come back, I feel good about it. So I'm going to want to work with one of the more lenient underwriters. I know the ones that are really strict that I use on some of my big commercial deals, and I know the ones that are pretty darn pragmatic is what I'll call it. And they're willing to listen to accept these kind of things. Another thing I noticed too is a lot of this has to do with your own credibility. I got younger folks in this business that go to the same title company I do, and that title company won't let stuff fly with them. But when I present some of this stuff to him, the title company says, I know Logan. I know he's got a really big business. He's got very strong business partners. And I've paid out. Title companies had claims before. They've come back to me and said, we're going to send you a demand letter. And I said, let's just talk it through. And I'd end up offering to pay them for a third of that claim because I value the relationship with them. We do a large volume of deals, and I need that pragmatic underwriting. So I've offered to reimburse them on some of them because it's a good business decision. So because they know that I can make good on my claim and back up their title policies sometimes, they're willing to let my stuff fly over some other guys.
So if you do insure over a deed of trust, which means you close without obtaining a formal release of that deed of trust,
right.
Do you have any issues on the back end when you go to sell? Let's say the buyer wants to go with a different title company, and all of a sudden, they're pulling title and saying, hey, that deed of trust is still lingering out there. We're not comfortable with it. Have you do those issues come up?
Yeah, that's happened before. I've had several times where folks will call me and say, I'm trying to sell this asset I bought from you. Title company's got problems. In that case, what we'll do is I'll pull the owner's title policy, the OTP that I was issued when I bought the property or when I sold it, and I'll send that over to the next title company who's trying to insure that deal. And usually they'll write on these words is what they say. They're going to write on the back of that policy or insure over that.
Mm.
So they're kind of basically saying, if we have a problem with our claim, we know that you have title insurance in your chain and we think we can pass the buck to you. So they'll insure on that.
Yeah. So they'll go ahead, Tyler.
And once you get a couple of those deeds recorded that have the owner, the GF number and all that kind of stuff, title companies quit researching so far behind that.
That's one of the things too that sometimes knowing the title underwriting policies under the Texas Department of Insurance, and then at the same time we have a land title association that has underwriting guidelines. Well, find the guidelines, find what they're complaining about, find the law, and then point out why, yes, this is your policy, but here's the law. So there's no exposure. So you were trying to over insure yourself. So if you can drop that down a little bit, then this covers you legally. And a lot of times, if you could present it that way without being over the top, like without being a lawyer, just being educated and not being too condescending or I'm smarter than you, then your underwriter can slide that through. But it also helps having a really good escrow agent, like somebody that can communicate with that underwriter.
Right. So to that point, for those deed of trust, 10 years after the date of maturity, if there's been no claim made to put it into default or to foreclose, but no release has been issued, in Texas, most of the title underwriters manuals will allow them to ignore that if it's been 10 years beyond the maturity date.
Do you have, other than the 10-year after maturity date, is there a specific statute of limitations in Texas that, if the borrower hasn't paid over a certain period of time, that the underlying promissory note or debt is, deemed satisfied and the deed of trust is supposed to be released?
So that gets into several different layers of law here. So you have contract law, and then what does the contract say? And so you have statute of limitations on, you got to sue within 4 years on a contract. So theoretically, the person that has the mortgage out doesn't pay in 4 years and they don't foreclose, then he could essentially sue at that point because they don't have a claim anymore. But Texas has some standing. So like where the mortgage holder has the standing, the investor that bought the property does not have that standing. I have investigated buying those claims. So when you're buying the property, getting that person's claims. So I'm dealing with a property right now that it has a ghost property attached to it. So it was platted in 1880. There's a half acre that wasn't platted and is not in the deed records, but has a house on it. But nobody it doesn't have a tax ID number. The taxes just roll over to the lot next to it, but not to this one on this half acre. And so what I'm doing, I'm buying her claims of adverse possession to that property. And then I'm going to have to go back in, replat it, suit to quiet title, and get it fixed up that way. Now that's super expensive and super long. The only reason it makes sense is after it's fixed, it's worth north of $500,000, and I'm picking it up for about $110 with a rent-ready house on it. So it has some more issues as well, but that's the one that makes it worthwhile.
So if you have the ability to resolve these title issues like the two of you do, I mean, that's a huge tool in your tool belt to find some pretty discounted properties, knowing that, you're going to have to put in the elbow grease and legwork to get them solved. But when you do, there's significant upside. So that's great.
Well, I mean, y'all know this. It's you've seen your bills. It's not cheap. It's not fast, and it's not pleasant. And at the same time, a lot of people don't have the stomach for the litigation. And you probably, this is one reason I have many clients, because I don't like having to school them on why we have to do what we have to do. And they're like, well, what about all this? I don't have the time or the patience to go through all these rabbit holes that you've been searching on Google. What we have to do, we have to finish this. Like, I would rather be watching cartoons with my kids than having 101, legal strategy right now. So that's kind of the thing. And one reason, I bounce things off of Logan a lot as if there's the business case and the legal case, and they have to match up.
Mhm.
Right. So the way my organization has kind of evolved is I've got in-house a genealogist and a private investigator, and I've got 4 attorneys that I work with. One of them bills about 80% of his time to me, and then the other 3 are billing probably 20% of their time. So you've got pretty heavy rep most of the time, and then me and a couple other guys in the office effectively work as project managers between surveyors, private investigators, attorneys. So it's become a fair business line for us because we understand the legal side, the business case, and we just happen to be really good deal makers and business people. But it's not out of the ordinary to buy stuff for 10 cents on the dollar. And that's anywhere from properties that are worth 50 grand up to, we got one that's 2.5 million right now.
So to switch gears from, deeds of trust and securing their release, I know, Tyler, you've been on, or at least I've seen you on another podcast, and you have some opinions on affidavits and memorandums recorded by other investors and dealing with those types of issues. Talk to us about what you might do if you're trying to close on a property just to find out that, there's a year-old affidavit or memorandum still lingering. How do you approach that?
I'm waiting. It's one of those things that the couple of times I've had the opportunity, they've been able to get worked out, or I didn't have the time. I was just too slammed up with actual lucrative opportunities to chase, a wholesaler down on this. My opinion on this is affidavits, memorandums of contract are brought up, and they have to comply with the statute of frauds. In Texas, the statute of frauds is delineated. It's in the Business and Commerce Code. I forget the section, but it requires everything to be signed. Right? Well, if you read the statute, it has to be signed by the person promising to do something. Well, in a contract, that's both sides. That's just not one party. So if your contract doesn't give you permission to place a memo, then it's fraudulent. And under Civil Practice Remedy Code, Chapter 12, that's a $10,000 fine per every person damaged. So if you file a memorandum of title or a memorandum of contract on an airship property, which I dabble in, and there's 50 heirs on it, that's 10 grand a pop times 50. And I'm waiting for that day to come out because everybody teaches this. And honestly, if you can't close on a property and you don't have the fortitude, the time, or the capital to fix the problems that you're trying to help these people with, then you either need to sue them for specific performance or take it to somebody that can actually fix the problem and knows what to do with it. But instead, you're waiting to hit the lottery when somebody does come along. And at this point, you're not helping anybody.
That's not right.
You're just a morally corrupt person who is trying to get paid. And that's not what, as a wholesaler, that's where bad names happen. Because I have nothing against wholesaling.
I had a conversation with a guy a couple of days ago, and he was basically telling me that he filed memos as a common practice to prevent him from sellers or other wholesalers or investors causing problems. And I said, look, man, I'm sure that your intent in the beginning is to be honest and transparent and do things right. And if you don't close on a property, you always release that every time, maybe. But sometimes you'll start to realize you have more power in that position, and it'll start to cause you to act differently. For example, the deal doesn't close because you and the seller got into an argument. Was he wrong? Were you wrong? I don't know, but you jammed up his title. You clouded him a little bit. And now he's calling you, getting ready to sell to somebody in a year. And you basically know you got him over the barrel, and you tell him, give me $5 grand for all my work. Man, that's bullshit. The deal didn't work out. You didn't sue him for performance. Yeah, you spent some time on it, but that's part of the business. That's going to happen anyway. Release the dang thing and move on. But people start to get this little power thing going on and say, no, I'm going to take some money. Well, who draws the line here? If you don't do those from the beginning as a practice, then it prevents you from getting into this bad place where you start to become a bad business operator. The way I told the guys the other day, he goes, you don't ever file them? I said, no. I close on the property, and if for some reason it doesn't close, I sue for performance. I don't ink deals that aren't great. They're all worth it, and I'm going to go after it, or I'm going to let everybody walk away. But that piece of paper out there is kind of some bullshit.
Well, I'm dealing with one right now that is going to be a fun one because it's one that I'm helping the family. Like I'm doing it. I call it pro bono because I'm only getting paid essentially my fees, like as in like how much it's costing me. So low bono, if you will. I'm charging $1,000 for fixing the adverse possession case and everything else, right? It's that nothing. I mean, I could have made more money just doing anything else, but the family needed help, and they contacted me. And good people went and met with them, figured out the case. And there's a memo by this guy that wasn't even signed by the owner. It was signed by her daughter, and she's still living. So I'm like, it's way fraudulent. So now that's the thing that this guy doesn't know. We're going to close around the memo because I've already got titles like, yeah, this is a fraudulent memo, but then we're going to close around it and then come back and sue him. Because I find that to be such a corrupt practice. Like, he didn't even get a contract signed. He didn't do the work required to be an operator in the space to go through and make sure that he performed his functions. He's got a contract signed. I could have got anybody to sign a contract and file a memorandum on your property, and now I hold you hostage with a cloud on title. Nah, that to me is criminal.
So in Texas, if the purchase contract gives the buyer the ability to unilaterally execute and record a memorandum, then is
then
there
it's
a
not fraudulent?
That it's okay to do it that way in Texas?
Okay. But if you're just if you don't have it specifically stated in there, then it's not okay.
The promulgated form doesn't have that here in Texas.
Right.
And a lot of folks don't specifically add that in there. So now you're in that spot. There early on in my career, I did those here and there. And what I did is I included a line item in the contract that clarified it. I would explain it to somebody, and the memo would be my very last page of the contract. I would sign it and the counterparty would sign it. And that's rare that both parties execute that memo. But when you do that, you have a different kind of document.
Yeah. And we have a similar statute in Arizona, like you guys have in Texas, except our damages are 5,000. So a little bit less, but it's the same thing. I mean, it is a pretty significant penalty to record a memorandum without authority to do it.
Yeah, I'm looking forward to the 40 or 50 airship property where there's somebody that I run a background report on, and they have the assets floating around out there to run up, just because it's got to stop, because I see too many people that need help and they're getting bent over a barrel, and it breaks my heart.
Yeah.
What do you guys, I want to move to another topic. What are you guys doing with bankruptcy these days? You got a property you love. You find out you got to deal with a bankruptcy.
So my thing is it doesn't bother me as long as it depends on who the trustee is, because everything's got to get approved for the trustee, and depends on whether or not the property can be legally brought into the bankruptcy or not. At the same time, a lot of times what I'm figuring out is they used to be a little more lucrative when I was first researching them back in 17 and 18. Now, with the property prices elevating, and everybody says, well, Zillow says, and the market's hot and the property's worth X, so the trustees are not as lenient as they used to be. So right now I'm not even chasing them, because it's one of those things that, like, the juice isn't worth the squeeze. It's not worth the headache.
Gotcha. So what about, we see this one. I always think this is an interesting one. Uncooperative co-owners. So, all the kids inherit grandma's house, and there's 6 of them, and 4 of them, or maybe 5 of them, want to sell it, but one doesn't because of whatever. What are you doing there?
Logan sues them.
Sometimes. So in Texas, we've got statute section 23 of the property code that's partition of real property. And the Uniform Partition of Heirs Property Act was passed, I don't know, in the last 2 years, I think. And that's section 23A that now affords a little bit of extra steps to help balance out the valuation and due process in that sale. It ultimately doesn't really affect the entire process too much, but yeah, you can get a judge to issue a sale pretty easily. And in that case, it's either homestead or non-homestead. That doesn't really stop this kind of sale.
It goes back to Betty Crocker. You just follow the statutes specifically, strictly. Like it's go to the property code. It tells you how the process is going to work. File the paperwork, run through the process.
The sad part is on these, I normally find the last person, the last man standing, he's like the last of the Mohicans. He's the fighter, he's the jerk, or she's the mean person, the liar of the family that held out, either that moved into that house and said, no one else can come here, I'm going to kill you. I literally have one like that right now. They're just they're usually the toughest person to deal with. They're rarely the person that pays all their bills, that has everything taken care of, and they're honest, just mean. That ain't that. They're the ones that didn't pay the taxes. They're the ones that have been living in the house for 10 years. They're the ones that won't help anybody do anything. And everybody else says, to heck with them. We like our money. So a lot of times when I'm involved, it winds up being me buying interest from 1 or 50. We did one with 65 people last year. That was the most I've ever done versus the last man standing.
A lot of times that's too, like these people that are doing it on the outside, it looks like you're the bad person when you're suing for a sale of the property, right? They're kicking them out of their home. They literally held everybody else at gunpoint and kicked their sister out of the house. Like, this is not a good person. Like, I'm buying somebody else's problem so they don't get murdered. Like, it's one of those things. It's not good versus evil. It's just that person's evil.
Usually, yeah, he's right.
Let's talk about the logistics of that type of transaction. So, Logan, you mentioned, okay, I'm going to go and buy the willing seller's interest in the property. So you're basically, let's say that you have, like Andy described, you have 5 owners, so they each have a 20% interest in the property. One's a holdout, and so you're going to go and you're going to buy, basically an 80% interest in the property. Is that accurate?
More or less, yeah.
And do you use title for that?
You can.
Or how do you close that?
So the first time I did that, I bought 1/9 of a property and thought that I bought the whole thing. I wasn't very good at abstracting, and I really didn't know what I was doing at the time. So I bought this one deed. Turned out I needed 8 more. And I went back to the title company I was working with at the time and asked them, well, hey, what about can you close? I had a big line share of them, all but one agreed. So I said, can I buy these 7/9? And y'all insure that transaction, so at least I know that's good. And they said no. It's like mineral interest in Texas, land title. They won't insure those. So you got to abstract. You got to know what the heck you're doing. You got to understand the intestacy chart, and you've got to be able to. Your attorney or their attorney or somebody in the deal has got to do the affidavit of heirships. In Texas, we're an affidavit of heirship state. We don't require probate for asset only deals, so you got to do that. So once you get that part of the process done, you can buy their interest. Just literally, here's the cash, here's a deed. That's it.
So basically you're buying. So in our hypothetical, you have 4 parties that want to sell and 1 holdout. So you would basically price their 20% interest and say, in exchange for your 20% interest, I will give you X amount of dollars. And then you're going to provide me with a warranty deed conveying your 20% interest to me. Do you use an attorney to escrow that, or is it at your office, or how do you, go about, making that exchange? Is there a settlement statement? What exactly are you doing to close those?
So we have a full closing package, just like a title company does. And we have a settlement statement. We have all that. The difference is our disclosures state that the person understands what selling is a fractional undivided interest that is more or less this percentage. Sometimes when we're buying it, we don't have all the airship work completely done. So we're having to just guess, it's not 10%, it might be 13. We don't know, but it delineates all that. We also have early on, we didn't have this, and we started doing this after a particular event, but now we have an oral, a form where folks read it, and they testify that they own the property. They're not under duress. They think they own about this amount. They're selling it for this amount. They're happy with it. They're of, sound mind and all that. And it's a video that we take at the closing. So it's a formal thing. It's an official deal. We have our attorney administer that closing, and he creates all the documents, and then we do the closing here in our office. And we ask the seller what they want: wire, cashier's check, or cash. We pay them.
So
all right.
I do one.
Go ahead,
I I do it on the hood of the truck sometimes with just $100 bills and a deed. We just scratch it out.
We've done that, but then we had some folks call us and say, "Hey, I didn't know what I was doing." And we said, "That's not the case at all." And they said, "Well, you took advantage of me and I'm going to sue you." And I thought, you didn't have any money to begin with. I don't know how you're going to do this, and somehow they wound up getting an attorney to rep them for a little while. And, we had to go in and get affidavits from the mobile notary. We ended up the person that sold this to us didn't have his driver's license because he'd just been out of jail for a few months. So he brought two credible witnesses there's a notarization deal in Texas. If you don't have a driver's license, you can do credible witnesses. So he brought two credible witnesses to sign that he was who he said he was. So we had to get all kinds of depositions, all kinds of affidavits from people to corroborate that he was of sound mind and yada, yada, yada. He knew what he was doing. But, you can spend 50, 60 grand just quashing that claim. And we'll get a judgment against this guy for attorney fees, but he ain't got any money anyway. So this is just a claim that you got to deal with. So that happens not very often, but those kind of things will happen in these type of transactions.
So I know you guys mentioned earlier, and man, I think Sean would agree. We could probably sit here all day and talk about all these issues. Yeah, there's so many.
Me and Tyler do talk all day about these.
I know. Maybe we should make this a regular thing. Yeah. I do want to pose one more. You mentioned it earlier, but I think it's you mentioned it in one of the most common mistakes that you guys find. And I think it's probably true on our end of things that it's a pretty common mistake. But how are you guys dealing with what's your practice and method in dealing with faulty deeds, incorrect legal description, or lack of proper conveyance, or misspelled wrong conveyance name, something to that effect?
So the cool part is this became such a problem with Texas had correction deeds. You go through the property records and you would find all these correction deeds. Well, 2017, the legislature finally formalized it and put it in the statute. So there's a process you have to follow for correction deeds. So there's non-material for Scribner error, or you bought track 8, but you're living on track 14 kind of thing. Well, that's a material correction, and there's a formal process to fix that. Otherwise, attorneys people were just drafting anything and filing in the property record. So now it's just a formal process, and you just have to follow the rules and get it corrected. Like, I'm dealing with a property right now that's very similar in that instance. It was subdivided in 1910. I'm actually having to go find heirs of the owners of the development company to sign deeds to correct that. So, I'm looking for heirs from people that died in 1940 and trying to do an affidavit of heirship on that person to correct this deed. Otherwise, it's a lawsuit, right? And it's a suit to quiet title. And who knows, how long that is going to take depending on who shows up.
Awesome. So give us an idea, Tyler and Logan, where can our listeners find you? What's the best way to find you?
Mine's through Facebook. It's one of those things I don't advertise much. I'll help anybody however I can. Shoot me a message. If it's a 5-10 minute question, I'll probably do it for free. Just a little guidance here and there. If it starts to be a little more in depth, we'll go from there. At the same time, if you got a deal, Logan and I are both the same. If the juice is worth it, we'll split it. If it's not, a lot of times I tell people, I'll take this deal on and I can pay you on the backside, but there's not enough in it for me and you to split it when I'm doing all the work and kind of situations. Cause a lot of these deals are ugly up front with time and labor and expenses.
What about you, Logan? What's the best way we can find you?
Same thing. If you pop my name in right there to Facebook, I've got a pretty good presence on there. There's a little bit of stuff on Google if you put my name in, but my office phone number is right there on our listing pages. So I encourage folks to call. I'm no different than Tyler. I enjoy talking about this. It's fun. It's a challenge. It's a journey. So folks call, talk with them for 20, 30 minutes about their problem and hope they fix it. And if they can't figure it out on their own, maybe we strike a deal.
Well, Tyler and Logan, we really appreciate you being on. I think if this illustrates anything, from state to state, laws change, but what needs to be the same to make this worthwhile is ingenuity, figuring out how to get the deal done, right? Wherever you are, you got to find ways to do it. And this has just been unbelievable information. We really appreciate your time with us, and let's do it again.
Sure.
Anytime. Thank you guys.
All right. You guys have a good
Thank you.
one.
All right. Bye, y'all.
All right. With that, we're going to go to brief discussion of what we got coming up next week. Best contract strategies to seal unique deals. Those are the deals, the unique deals that we use or work with investor clients to get the deal done. We're going to have a guest on to discuss that process and what we do to get that done. Thanks for being with us today. We'll see you guys next week.
Have a good day, everyone.